Hello everyone. In this video today, we are going to be discussing a very important topic, the topic of high courts in India, and we are going to understand the territorial jurisdiction. I'm going to be telling you about the background of high courts in India, what were the acts with which they were made and how exactly they have been implemented in India. That said, let us quickly start off with the topic today. Now, as all of you know, the institution of High Court in India, we all know that the institution of High Court in India was originated in the year 1962. The very first time we had High Court set up in India was in 1962. The very first High Court of India being the Calcutta High Court. Now, this was obviously followed by the Bombay High Court and the Madras High Court as well. So, the first High Court in India was the Calcutta High Court, followed by the Bombay High Court and the Madras High Court. At that point of time, you all know that we were under British rule. So, the British had passed the Indian High Courts Act, and by this act, they mandated the creation of 3 high courts in our country. Obviously, first Calcutta, second Bombay, third Madras. The reason I'm reiterating it for you is in many law examinations we find these questions. Which was the first high court in the country? Which was the second? Which was the third? Now, the fourth high court in the country after Bombay, Calcutta, Madras and all of that, was the Allahabad High Court. And the Allahabad High Court was not set up during British rule. So during British rule, we had only 3 high courts in the country. The Allahabad High Court was the first high court which was set up after independence. And this happened in the year 1966. See, after 1950, a high court was existing in each province and it became the high court of the corresponding states. Now, as of now, guys, if you know, we have approximately 25 high courts in the country. We have 25 high courts in the country, which has been established in different states of India, right? The most recent high court that has been created, the most recent high court that has been created is the Andhra Pradesh High Court, right? It basically started on 1st January 2010 and it started operating at Amravati. Now, Article 214 to Article 231 of Part 6 of the Constitution of India deals with the organization, deals with the independence, deals with the jurisdiction and powers of the judiciary and so on. The Constitution of India, for that matter, has provided for a high court for each state. But just remember one thing. The parliament here is authorized to declare a common high court for 2 or more states. So the parliament has been given this power to declare a common high court for more than 2 states. The jurisdiction of the territorial jurisdiction of the high court is usually coterminous with the territory of the state. But even with that, we have 5 exceptions. And I'll be telling you about these 5 exceptions by the end of this lecture today. Also, the parliament can actually extend the jurisdiction of the high court. It can curtail the jurisdiction of the high court over a union territory. Okay, one more pointer over here. The Delhi High Court as of now is the only union territory in the whole of India which has its own high court, which has its own court. That's it. And this court was also established in the year 1966. Okay? Alright. The next slide. Now, when we come to the organization of the High Court, see, every High Court usually consists of a Chief Justice, right? And any number of judges which will be decided by the President of India. So, obviously, the High Court has its Chief Justice and the number of judges that are required over there will be decided by the President of India. Remember, the word parliament here has absolutely no relation. Okay? The Constitution of India has not specified the number of judges in every high court. For example, we all know that in the Supreme Court of India, we currently have 33 plus 1 judges. That means we have 1 Chief Justice and 33 other justices. This has been mentioned in the Constitution. However, in the case of the High Court, the number of judges have not been mentioned at all. So it is left to the will of the President to decide how many judges will be there in the High Court. Okay? Now, whenever we talk about the appointment of judges, जब हम judges की appointment की बात करते हैं, याद रखना High Court के सारे judges जो है वो President of India appoint करते हैं. Number 1, the Chief Justice of the High Court, as you know, is appointed in the consultation of the CJI and the governor of the state concerned. Remember, This consultation is binding in nature. So we all had the three judge cases, right? The three judges case. And in these cases, the consultation with the Chief Justice is absolutely binding in nature. All right. So if there is a common high court for a couple of states, the governors of all the states are going to be consulted. Okay. Now, when we talk about the other judges, when we leave out the Chief Justice of the High Court, we talk about the other judges. It is opinion that this Chief Justice should have a collegium of two more senior most judges of Supreme Court before recommending the name to the President in a third seminal judge's case, as I've already told you. Now, the third judge's case, guys, was basically happened in the year 1998, right? And this instituted the collegium system in India. Now, the collegium system is the way in which judges of our country are appointed. Now, also we've also had a fourth judge's case of 2015. The fourth judge's case, however, basically deals with the invalidation of the National Judicial Appointments Council. Please do not get confused with the three. So we all know that there are four judges' case. However, the fourth one just invalidates the NJAC, the National Judicial Appointment Committee, right? However, it does not actually deal with the appointment of the judges of the courts. That is why we usually do not talk about it too much. Now, as all of you know, when we talk about the jurisdiction of the High Court, the High Courts have multiple jurisdiction. For example, the High Court has what we call original jurisdiction. Now, the original jurisdiction of the High Court is usually narrower than that of the Supreme Court. The original jurisdiction means whenever a court is a court of first instance, that means a case can directly go to this court. In that case, it is known as a court of original jurisdiction. Now, for original jurisdiction, there are not many matters in which the High Court actually can work. However, when we talk about writ jurisdiction, right, Article 226 of the Constitution, we usually say that the High Court is the court of first instance, right? It can also act as an original, jurisdiction when we talk about it. In matters of revenue, in matters of contempt of court, in matters of transfer of cases, the Supreme Court has the High Court has the ultimate power over here. Basically, it has original jurisdiction in these cases, right? Okay. Now, obviously, the High Court will not take care of any type of federal dispute which is happening between the center and happening between the states. So, any kind of federal dispute, a dispute between the center and the states, it will not be referred to the High Court. It will directly go to the Supreme Court. However, when we do talk about the writ jurisdiction of the High Court, we should know one thing. The High Court, for that matter, has wider jurisdiction than the Supreme Court. That means the writ jurisdiction of High Court is wider than that of the Supreme Court. Article 226 of the Constitution gives the writ jurisdiction to the High Court of our country. Now, this is going to be for the enforcement of fundamental rights or any other, or any other purpose. So other than an ordinary legal right, you can talk about an ordinary legal right, you can talk about another right, anything at all. See, Article 226 of the writ jurisdiction of the High Court is not exclusive in nature. However, whoever has had their fundamental rights violated, abridged or contravened can directly go to the High Court without going to any other court, right? And in the Chandrakumar case, the 1997, the Chandrakumar case, the Supreme Court had said that the writ jurisdiction of both the High Court and Supreme Court is a part of the basic structure of the Constitution. So basically, it is the right of the High Court to take up matters in the suo motu basis also. See, apart from that, we know that it has appellate jurisdiction, it has supervisory jurisdiction over the other courts. Whatever things come to it by the way of appeal, cases come to it by the way of appeal, it can take that up also. We also know that it has control over the subordinate courts. It acts as a court of record under Article 215. We all know all these points. But the major question remains, when there are 25 high courts in the country, right? In total, there are 25 high courts of the country, and this includes one High Court of Delhi. that seriously means that there are many other high courts, that there are many other high courts, that there are many other union territories and states which probably share a common, which probably share, they share a high court. Let's try to understand this. Now, all of you know the Bombay High Court. Obviously, it is located in the state of Maharashtra. So, obviously, Maharashtra ka capital was Mumbai, is Mumbai, and Bombay High Court becomes the capital of it. But it also has its jurisdiction over Goa, over Dadra and Nagar Haveli, and Daman and Diu. So, if you look at the map of India, right, you will see that Goa, Dadra Nagar Haveli, Daman and Diu, these are certain places which are very, very close, which are very, very close to the Bombay High Court. That is why it is usually extended to these places. Similarly, when you see Kolkata High Court, you see Calcutta High Court, right? It is located in West Bengal. And it has jurisdiction over Andaman and Nicobar also, because it has the best connectivity to these places. Similarly, the Guwahati High Court in Assam not only takes care of Assam but of the other northeastern states as well. For example, it takes care of Arunachal Pradesh, it takes care of Mizoram, it takes care of Nagaland also. The Kerala High Court obviously is located over here, and the Lakshadweep Islands, since it is the closest to it, it has jurisdiction over it as well. The Madras High Court not only takes care of Tamil Nadu, it also takes care of the Puducherry area, again located very close to it. Similarly, the Punjab and Haryana High Court, they obviously take care of Punjab, Haryana, and the Union Territory of Chandigarh. So the only one high court that you're going to see is far away from the territory of the high court is going to be Andaman and Nicobar. Apart from this, all the other high courts are very, very located very, very close to the, they are located very, very close to the state. Now, to understand this, I would give you a very, very small homework. Make sure that you are going home. Make sure that you're going home. I'm going to give you a small homework. Make sure that you people are going home, actually opening all your slides, opening a map of India, and start marking the high courts of the different places. I want you to do this exercise at least 2 times. If you do this, trust me, you will never be able to forget any of the high courts and where their jurisdiction extend to. Okay? So with that, guys, we come to an end with the session today. I thank all of you for being online, and I hope all of you enjoyed the session. Please take care of yourselves and click on the subscribe button down below so that you can get a regular update whenever our videos come forward. Thank you, guys. Bye-bye.